Good morning, everyone, and welcome to this edition of MacroPro and Friends webinar series. I'm Diane Cohen with MacroPro. It is lovely to have you join us today. And today I'm joined by Martin Guzman. And Martin and I have known each other a long time. Martin, we met at a pool, I think it was a poker game, right?
Yes, you almost said pool.
Yes, exactly. So that was probably back in 2005, I think you said, at a defense conference. So tell me, what has happened since then? Obviously, a lot has happened. Where are you now?
Well,
what are you doing? What firm are you with?
well, if you remember back then, I was a newbie. That was, I think, my first or second conference I had gone to, met you there. Now I'm at my own firm. We were previously Patrico Hermanson Guzman. Now we've changed our name to Hermanson Guzman and Wang. We changed that effective March or so, and we've opened up an office in Boise, Idaho. They say it Boise, not Boise. And at this point, I'm looking for another office to set up perhaps before the end of the year in Arizona to help our clients that are in Arizona.
Well, who gets to work in Boise?
With that?
Who gets to work in Boise?
Of course, yours truly. I'll do the treks back and forth.
Yes. Well, you know, after COVID, we all get to work from home. So a lot of that happens from home. I understand you were in a hearing this morning before this. So it's, okay. Yeah, you certainly can do everything from your own computer these days. All right, Martin, before we get started and before you introduce your guest speaker, I'd like to go over a few things for our guest here watching today. Today's webinar is worth 1 California CEU credit. You will receive an email today, roughly 1 hour after the presentation, and they will send you a CEU credit. You need to make sure that you are logged on to the GoToWebinar platform, otherwise you will not receive it if you're just calling in. If you have any questions, please be sure to put them in the question box, and I will ask them as they come up and as time allows. Any questions we don't get to, I will make sure that Martin and his guest speaker gets a copy of it, and that way they can address it to you at a later time. And then lastly, there are handouts that are attached to this webinar. Please make sure that you download them so you have the information at your fingertips. And if you just love this presentation so much you want to see it again, it will be on the MacroPro YouTube page. So Martin, take it away, introduce your guest speaker, and I will talk to you later.
Okay, so a little bit of background. My name is Martin Guzman. I've been in the industry for, well, too long, since 2004 or so. We practice throughout the state of California, now in Idaho and soon in Arizona. We have offices throughout the state. That's my shameless plug for the day. Introducing now, I'll have Chanel. She's our newest attorney out of Sacramento. Chanel.
Hi, everyone. So I'm a little bit of a newbie, and this is Martin and my first presentation together. The last time we were together in person, I believe, was at the WCAB crab feed. So bear with us as we kind of learn our little mojo together. Should we get started, Martin?
Oh, yes, absolutely. So today we're going to put on our presentation in a question and answer format, much like attorneys learn the law in law school. So go ahead, Chanel.
All right, so our first topic is everyone's favorite, utilization review. And the question that was posed in Elaine Holgan is, does the defendant need to submit a request for authorization for treatment to utilization review if it had previously been denied and there were no change in material facts? So the relevant law here is going to be Labor Code 44610K. So a utilization review decision to modify or deny treatment, it is effective for 12 months after it has been made. And an employer does not need to make any further action unless there has been some sort of change in material fact. So once the decision's been made, the decision's good, no further action by employer until the doctor gives good reason. So that is also a addressed to claims administrators due to Administrative Directive Rule 9792.9.1H. So the same rule applies there to claims administrators. So just make sure once a UR decision is made, you don't need to do anything until there is some sort of change in material fact. So in this case, on August 27, 2021, a doctor named Dr. Smalls issued a request for authorization for a functional restoration program. And he provided a narrative report and to kind of explain what was going on. And then on September 3rd, 5 days after, Utilization Review issued a non-certification recommendation. Disagreeing with that, Dr. Smalls once again submitted a RFA on September 13, 2021, where all he did in that, he didn't give any reason for a change of material fact, anything like that. He just said, hey, I disagree with you. Here are my reasons. I don't care what you said. This is what's going on, and you should listen to me. So after that, independent medical review came back with a final determination letter that approved what UR had originally said. So in this case, the judge determined that Dr. Smalls gave no information at all, other than, hey, you're wrong. The applicant has to have something that changes from the day the first RFA is issued and denied by UR. Arguments and opinions as to why the UR decision is wrong, it does not constitute any change in material fact that would require an employer or claims adjuster to make any further action. If you get an RFA that says the same exact thing or just argues with UR, you can kind of just put it aside and leave it alone without any consequence.
Okay, so in this case, what did the doctor say? Do you recall, Chanel, regarding the, what was this, a functional restoration program? As to why?
He just basically said, you're wrong, and here didn't really give much of medical reasons. He just, I guess, wanted to argue.
It was my doctors know better, and of course, these functional restoration or functional capacity type programs, they're not cheap. They're about $5,000 a week when they get in. But in this case, the doctor, for tips, the doctor explained why he disagreed with the utilization review, but he didn't give any evidence. And so just submitting a rebuttal report, which I see a lot of times these doctors do, is they'll submit a rebuttal report and say why it's wrong, but they don't offer anything new. And sometimes they'll check off the box that says change of circumstances, but their change of circumstances is, I'm going to give you more. But as a practice pointer on this issue, you need to be careful when it says change of circumstances, because utilization review may have denied it because perhaps they weren't able to get a hold of the doctor and they didn't give them enough information. So what happens if the doctor now gives you the additional information? I would say that there's a potential for that to be considered new facts or material change, because now you're getting the explanation, especially if it's followed up with a narrative report as to why the individual needs the proposed treatment that they're requesting. But if it doesn't, then what you're looking for when you get the revised or updated RFA is you have to look for the documented condition change in the patient. Perhaps they moved on from conservative care and now they want to try an injection, or they tried an injection for surgery and now the injection is proven not to be accurate or provide relief, so now they want to try a surgery or something different. That would be a material change because they've exhausted the conservative care. You may want to consider submitting your RFAs. If it's unclear to you, just submit it to your UR. Don't make a snap decision like, oh, this isn't anything. You have to look at it carefully, and perhaps UR, and I know it's an expense for you guys, but you can try submitting that as they come in and they can decide whether there's any change. But before they send out that approval or authorization, make sure you review to see if there was a change in the in the condition, and don't miss that deadline. Sometimes the doctors will have a peer review, or they'll call you to try to discuss the case, because I see many adjuster letters typically send out a notice that you'd welcome a conversation as to the treatment to discuss, and they feel that you're incorrect. That review that you have with them, do you have that? Is that something that would reflect a change in those circumstances?
All right, Martin, why don't you tell us what happens? Worst case scenario, you do not do a timely utilization review. This case is wild.
And you've got to pay lots of money. So the question in the next case in Castillo, Reina, is whether or not, if you make a determination within 5 days, but you don't properly serve it, is that timely for you? And can a judge rule on a treatment in perpetuity? Well, our standard go-to response to that is, it depends.
Every attorney's favorite answer, it depends.
Okay, so in regard to the utilization review timeliness, any time that you're going to make a decision, you have to do that within 5 days from receipt of the written request for authorization. And the 5 days, that's 5 business days. So if it comes in on a Friday, you get the 2 extra days for over the weekend, or if there's a holiday. And if it's after 5:30 when it's received, then that doesn't count. It goes to the next day when you start doing that. And that's pursuant to California Code of Regulations 9792.9.1A1. If you have a denied claim, however, you don't have to submit it to utilization for review, but don't forget that once you accept that claim, that it triggers it. Once you accept, you have to conduct all your utilization review within 5 days of the determination that you have liability, or if a judge finds you liable on a claim for AOE-COE. Okay, so in this case, the employee was working as a laborer from 2000 to 2001, and he had industrial injuries to multiple body parts, and he had a specific injury in 2001. He was off for a bit, but even after that, the employer paid him for his money, and he underwent several surgeries. The doctor requested physical rehabilitation for outpatient services. This was the Colima nursing facility, right? No?
Yes.
Okay. And so what happened in this case is they asked for 5 hours a day for 4 weeks. And as you can imagine, outpatient nursing facility care is pretty expensive. So that was authorized by the carrier for the 4 weeks. And then after that 4 weeks had lapsed, the doctor asked for an additional 20 sessions. And that was granted, and the time period to complete that was about 4 months after the authorization was granted. And then come the time when that expired, which would have been in the summer, about July, then the doctor submitted another request for authorization. But all along, the doctor was documenting that the patient was having improvement and recovering well. And the background on the injury is that they had a post-concussive syndrome. They had a CT scan that showed that they had soft tissue injury in the brain, and therefore the nursing care facility was providing neurorehabilitation, helping them recovering. And they documented every time they submitted a report, they were documenting that the patient was improving. And when the carrier received the the RFA request in July, they issued a denial. But what they did is they sent it to the applicant attorney, and they put the wrong suite number. No one made the allegation that they didn't get it to the applicant. If the applicant did get it, they didn't raise that as an issue. They focused on the fact that the attorney wasn't served. And pursuant to rules of court and regulations and workers' compensation, if you don't serve a party to a case that should be served with something, then that's not proper service. So they treat it as if it was ineffective. And in this case, the regs require that any utilization review that non-certifies treatment, it has to be copied on the representative of the injured worker. So in this case, it was defective because it went to the wrong suite and the attorney didn't get that. And to top it off, the applicant filed a DOR and they didn't get the denial or the non-cert that was issued until the date of the hearing. So it was at that point that the attorney for the injured worker first found out that they had issued a denial. Allegedly, I'm not sure that the injured worker wouldn't have told them that they got a denial, but since they could probably see on the proof of service it went to the wrong address, they asserted that so they could get this authorized. But in any event, the judge asserted jurisdiction. Typically, you don't get jurisdiction for utilization review issues unless something takes it out of there. So this is a procedural issue that would have granted them the ability to hear the case. That's too bad for the carrier. So at the hearing, the injured worker and his attorney presented testimony from the facility that they were being helped by the treatment and that they had submitted the RFA requests, etc. And the whole argument was that service was not proper. So in this case, the judge found that the defendant was liable for the continued outpatient rehabilitation services until the services are no longer reasonably required to cure or relieve the effects of the industrial injury. In addition, the judge found that because they didn't serve the UR determination on the applicant attorney, the board had jurisdiction to make that determination under existing case law. And the judge found that the UR was invalid under the circumstances and that they'll continue to get the treatment. This is all controlled by California Code of Regulations 9792.9. And I won't bore you with that, but it comes down to the 5 days and it has to be, the RFA has to be received by the carrier by certified mail, return receipt with proof of service, all accompanying reports. There's always little issues that you can raise with the service of the RFA if all else fails.
All right, my turn, Martin?
Yeah.
Okay, so just a few pointers here. So an applicant must still meet a burden to prove that the treatment requested is medically necessary. So they can't just show up and say, hey, this is what's going on. My doctor said so, so I get to. They have to show that it's actually required. By doing that, it needs to be substantial medical evidence, so just documented proof. And the defendant has to provide medical treatment. And as you see, it's medical treatment reasonably required to cure or relieve the injured worker from the effects of his or her injury. So if there's some sort of medical recommendation, a prescription, some sort of proof that this demonstrates that there is a medical need for such services. So a defendant cannot just unilaterally terminate, and in this case, it was the applicant's home health care, because there was no change in evidence of the applicant's condition or circumstances. So in this case, it just, the applicant was continuing to improve. There was nothing that said that, you know, okay, well, they're good, they can go home now. So, yeah. Okay, so a utilization review decision that is timely made but not timely communicated is deemed untimely. So one of the best ways to avoid this is just to make sure that the addresses are correct, that your counsel knows that the addresses are correct, and that there's just good communication between you and your attorney. So even though where the UR decision was untimely, the injured worker is nevertheless only entitled to what is reasonably required medical treatment. And the employee needs to be the one to establish the entitlement. We, as defense attorneys, do not need to, and claims administrators.
Okay, some of you may recall on these issues of utilization review. The one that comes to mind was cited within this case, and that's the one where a carrier provided a nurse case manager to help with the applicant's appointments. And I also consider that case as the no good deed goes unpunished, because the carrier willingly provided that service to help the injured worker schedule and attend their appointments. That was all. And then the nurse case manager was withdrawn from the case, and the applicant attorney filed for a hearing saying that you can't take away the nurse case manager because you're providing it, and there's no change in the circumstances that would warrant that. So that's what they bootstrapped to do this on the utilization review, that if there's no change, so basically the doctor says they need to participate in this type of rehabilitation and they're showing progress, that can't be stopped until there's a definitive showing that they don't need that anymore.
All right, so this one is about setting aside stipulations. So the question posed in this case is a stipulated temporary disability indemnity rate binding in all circumstances? And basically comes down to, are we stuck when we stipulate? And spoiler here is the answer is almost, it depends. So, but the problem is it kind of almost feels like usually it only depends if you're the defendant. So it's just, in my short time of doing this, that's sort of what I've already noticed is kind of like the trend. So
the story of the adjuster's life. We always lose.
all right, so Martin, you gonna let us know what rules apply here?
Of course. All right, so in regard to stipulations, anytime that you have an issue that goes before the board, you can agree to something, and if you reduce that to a writing, the court doesn't necessarily have to make a decision on that, and they can accept your stipulation. But because this is workers' compensation, the judges are instructed that they need to make sure that any agreement or stipulation that is presented to them is in the best interest of the injured worker. So that's where this labor code derives from, that, well, not derives, but it addresses some of those principles, and that the judge, even though you stipulate to something, the judge can inquire and determine if that's actually in the best interest of the injured worker. So in this case, if a judge doesn't agree with a stipulation, they could take testimony and review additional documents to make sure that that issue is being stipulated correctly or properly. And before we discuss the case, just a small refresher on the way we calculate average weekly wages and TTD. So TTD is typically calculated, you multiply the average weekly wages by 2 and divide it by 3, that'll give you your rate, but that's based on the earnings. And the earnings, if you work more than 30 hours a week for an employer, you take your earnings and divide that basically by the week, or if it's by hours, and you come up with the average wages. And then if you can't do that, there's always a catch-all. There's a few other methods that you can use to calculate the rate between multiple employers, irregular, piecework, things of that nature. But then there's a catch-all that basically instructs that in order to come up with the average weekly earnings, if you can't do it with any of the other formats that they provide, then you have to look at the totality of the circumstances and see what best reflects the earnings of the employee at the time of the injury. And I call that the catch-all. And that could involve things like subsequent raises, get compensated or bonuses that are reasonably anticipated, things of that nature. And you have to keep in mind that the WCAB and the judges, they will always look to achieve substantial justice between the parties, because we're dealing in a benefit delivery system, and these facts, well, not the fact, but the law is what's supposed to be construed in favor of the injured worker. So in addition to doing the TTD rate for 2/3 and at the time of the earnings of the injury, don't forget that there's a 2-year rule that if they're on TTD after 2 years, you have to look at the earnings that they had at that time will justify a higher rate based on that point in time. Okay, so for purposes of this case, the estimate of earning capacity is a prediction of what the employee's earnings would have been if they weren't injured. So what would they have been earning with TTD, because that's replacing their wages. So if I'm injured 3 weeks ago, but I'm not off work and now I am off work, what would be the best prediction of what I would be earning while I'm off now? That's the point of that. And under 4453, we know that we have to look at what is that best way to do that.
All right, so let's talk a little bit about what happened here. It's a little bit more fact intensive because it sort of depends on the date. So the applicant was originally injured on October 13, 2019. He went to a QME. He found the applicant to be TTD beginning January 17, 2020 and continuing on since that date. The applicant was scheduled to receive a raise and did actually receive a raise in November of 2019. At the January 28, 2021 MSC, the parties stipulated to an average weekly wage that considered the wages of the employee at the time of the injury. So it did not preclude consideration of the applicant's scheduled pay raises shortly after the date, but it did set an average weekly wage rate. So in this case, at the MSC, the judge actually kicked down the issue of TTD because there was a pending EDD lien. So that needed to be resolved before any award of TTD was given.
Next.
So what are some reasons as to why a stipulation could just be thrown out? So there needs to be good cause to rescind, alter, or amend the award pursuant to Labor Code 5803. And so how we do that is by showing some sort of fraud, duress, undue influence, mutual mistake in fact, mistake in the law, invalidity of execution, incompetency, or minority at the time of execution of the agreement. So a party can also seek relief from a single party's mistake where the mistake was due to the fault of the other party, or the other party had reason to know of the mistake. So how do you get out of the oops? If you stipulated a hearing, such as a pretrial conference, you might not be bound in those stipulations, regardless if it's a defense or applicant issue or mistake. So in this case, the applicant's argument was the following. The applicant argued that the average weekly wages stipulated only reflect his earnings at the time of the injury and not his earning capacity. So what should be taken into consideration is his scheduled pay raise shortly after the date of injury. So the stipulation did not preclude consideration of the applicant's scheduled pay raise shortly after the date of injury. The second argument the applicant made was at the time of the MSC, the defendant had direct knowledge of the fact that the applicant's hourly rate, of what the applicant's hourly rate was and his scheduled raises. So basically, he argued that that wage stipulation arose out of mutual mistake of fact, and therefore he should be relieved of the stipulation. So yeah,
what was the mutual mistake here, though?
Not really sure. I mean, I think it's the fact that he had this raise and it wasn't taken into consideration by the parties at the MSC, because at the time there was no actual wage check or anything provided.
Okay, I think in this case, the recon unit basically said that the defendant knew the raises, right?
Yeah.
They were expecting their attorney to know that at the hearing, which we don't always know. So with this case, would you agree that it's the issue if I get injured 3 weeks ago or a year ago and I don't go on TTD, and let's say, for example, I get a 20% raise, which I wish, but let's say I get a 20% raise, or perhaps I move on to another employer and I'm earning something that would generate a TTD rate that's maybe double what I would otherwise get if I only use what I was earning when I was injured. So if I don't go off on TTD until I'm making all this new money, is that we're going to use that new wage to calculate a TTD rate, right?
Yeah, that's exactly what it is.
Okay, so what if they were to go off work the same day of injury and the raise that doesn't come up until after and it wasn't planned? That wouldn't apply, right?
I believe it actually would apply, because the whole point of TTD is to put the applicant at where they would be had they not been injured. So if there was a scheduled raise, like let's say my job definitely told me, Martin, that after 6 months or a year of working for my employer, I will be given a raise. So there are some jobs out there that you start off on, you make X amount per hour, but once you're kind of out of your initial trial, then you get an X amount of pay raise. So in those situations, if the employee had not been injured and continued working, he would have made that higher amount. So that is what we basically base the average weekly wages on.
Okay, so basically we don't want to shortchange the injured worker because they had an injury and now they make more money.
Yes. Okay, so this is kind of where, coming from a civil background now in workers' comp, it sort of seems like judges can be like, this is what's going on and this is how I feel, so let's do it. So while stipulations between opposing parties considering the existence or non-existence of material facts are permissible in workers' compensation cases, they're not binding on the appeals board or a referee. They can reject a stipulation and base the decision on evidence provided at the hearing. So a workers' compensation appeals board does not exceed its authority in making findings contrary to stipulations. And that's based on 5702. So they can take further testimony and make further investigations and then do their own, kind of go from there. So when the defendant has direct knowledge of the applicant's hourly rate, when they know of scheduled raises, basically if they know anything that's going to change in their raise if the employee had continued working without injury, then the judge says that at that point, the wage stipulation in this case did actually result as a mutual mistake of fact. So the stipulated temporary disability indemnity rate was not binding because they said the defendant, whether or not they were actually aware, should have been aware that the applicant's hourly wages were going to go up. And accordingly, the applicant's TTD indemnity award should reflect the verifiable wages that the applicant would have earned had he not been injured.
All right, next up is one of my favorite issues to defend my clients on is dates of injuries and cumulative traumas. The questions presented by this case in Saavedra is when is an injured worker put on notice that they have a disability, and can you find disability prior to an employee becoming permanent stationary? And again, the answer is going to be depends, and also depends on what you want to do in your case, especially if you have someone on the other side that might not understand the way these labor codes and the dynamics work on exposure. So I'll spend a little bit of time on this. So this involves the interplay between Labor Code 5500.5 and Labor Code 5412. 5500.5 addresses liability between carriers. So that one, that case, that labor code indicates that the liability is fixed on the date of injury pursuant to 5412 or the last date of injurious exposure, whichever occurs first. And so 5412 tells you that your date of injury is when you first have disability and you knew or should have known that that was caused by your injury. So what is disability? Disability can be temporary disability, it could be permanent disability, and permanent disability can also be demonstrated by diagnostic imaging, perhaps by the prescription or dispensing of durable medical equipment, a permanent modification of your job. These are all things that could be used to indicate that you have a disability, because after all, if your employer permanently modifies your job because you can't do something, that is a direct indication that you're disabled from that portion of your job duties. You have a disability or impairment. Sometimes if we don't have a disability, the board may decide that they're going to base it off medical treatment. And that typically happens when someone has a cumulative trauma and they're still working for the same employer, but they never lost time. And they end up going to a doctor to get an NMI report. And that, or even if there's no permanent disability, they'll use that as a date of injury. So in this case, what we have is an agricultural laborer. He was harvesting strawberries, and he worked in that type of industry for quite a number of years. And he sustained a specific injury in April of 2016, and he was off of work, but he didn't get paid TTD. The employer paid his wages, so he had time off for that, but no TTD. Then in 2017, about a year later, he filed an application alleging a cumulative trauma, which included the bilateral knees. And they brought in multiple defendants in this case. Everybody's saying it's not my fault, it's yours. And he kept working. The parties asked for the QME in the case to issue basically an advisory disability report, because I presume this guy was still working or was going to keep working. It didn't mention it in the case, but that's typically when that happens, and they want to see if they can resolve the claim, or maybe there's no more exposure to the carriers that are actually involved in the litigation, and they want to see if they can CNR because he's already got new employment and perhaps new insurance and someone else to peg with additional liability after he settles. But in any event, the doctor that evaluated him did so in September of 2017, and the doctor commented in his report that I'm using the AMA guides to provide impairment, and he had some diagnostic imaging that showed bone-on-bone cartilage loss, and rated him accordingly using that. He didn't have to use an objective or anything else because that was already evident in the diagnostic imaging. The case moved on for a trial, and the issue at trial was, what's the date of injury for this case? One defendant was arguing that this was in May of 2018, which would very likely be outside their coverage, and they wanted to dump it on people after that date. And another defendant argued that no, it wasn't until 2017, in September 2017, when the injured worker was evaluated. And the doctor, again, he based his disability based on some bone-on-bone knee arthritis.
Also important here, you guys, is that there was no dispute as to the fact that there was a bone-on-bone injury. So that was never really an issue in trial, which is important here.
I have a few questions that came in, so we're going to digress a bit for a second, if that's okay.
Absolutely. Sure.
All right. So I'm reading them as they come, and some of it's shorthand, so hopefully I'll do an okay job for you. I had a problem with UR. They do not have to review the psychotherapy. The session is $125, and the treatment is $1,800. But the UR keeps sending it back to me. Do you know how to resolve this issue?
Okay, so if I understand the question correctly, they get a request for treatment and UR just kicks it back without review.
Right, they don't want to review it.
Yeah. Unfortunately, the adjuster cannot make a medical determination as to whether something is reasonably medically necessary. That is solely on utilization review. It could be that maybe the psych portion of the claim is denied and that's why they don't want to review it. I would look at that, but other than that, I would recommend escalating that because utilization review, I believe, can review things even if they're denied and just provide an advisory cert or non-cert for that requested treatment.
Right, next one is, I have an election clerk who worked only during the election period, got injured. How do I calculate AWW PD rate?
Okay, in that situation, you would need to have the election clerk give you all their earnings for the past 2-3 years, because that's what you're going to use to see what is their earning capacity. It could be that they only work every 5 years, or that they only come up for work here and then. If that's all they've done is election clerking, that's what you're going to use as the average weekly earnings. And the way you do that is you look at the election season, election cycle when they work. You take, let's say it's 2 months, 3 months, you take those 3 months and you take their earnings during those 3 months and you divide it by those 3 months to come up with an average earnings. You don't have to extrapolate it. This would be similar to the signature fruit case that holds, again, TTD is meant as a wage replacement. So if you're seasonal and you only work a season that lasts 3, maybe 6 months, then you only get paid TTD during those 6 months. Granted, it might be higher than if you extrapolated it over the year, but it's only intended to replace your wages when you are working and when you're expected to work. So that's what I would suggest in this case is you take the time that they work and you do it during that time frame only. And when the season ends for the election cycle, that's when you stop.
All right, and did the workers' comp judge allow the TD increase due to the scheduled salary rate increase?
In that case, I don't believe it would particularly have mattered. I believe that they simply indicated that it would be manifestly unjust not to include it. And this would go to the issue of you get an increase after 2 years of your TD rate to look and see what your rate would be warranted depending on your earnings. But that typically applied, let's say you earned $1,000 a week on the date of injury, but because it was 2 years ago, your rate was capped at 500, whatever. I'm using a made up number. But then 2 years later, that cap has gone up to 700. You're still using the $1,000 to determine your TTD rate, but now it's capped at 700. So you're going to get that bump. It's a similar analogy, but what they're looking at is if you are working and you don't have TTD, but 5 years later, you've earned more money, it would be unfair for you to go off work because of your injury 3 years later and not consider your current earnings at the time when you go off work. And that's what they did in this case.
All right, well, thank you. That's all the questions we have time.
Okay. Okay, so going back to this case, what the findings were is the doctor indicated that this was clearly rateable using the AMA guides because of the findings of the arthritic condition, and it could be seen on diagnostics at the time of the evaluation.
All right, so the defendant argued that the applicant was permanently disabled starting at the actual supplemental report, which was on November 3rd, 2017. However, the doctor in that report continually referred back to his September 12, 2017 report. So he kept saying for all the subjective and objective factors used to calculate the permanent impairment, please refer to specific pages in his prior report. So the court found that it's clear that the subjective and objective factors that were used by the PQME in this case to calculate the permanent impairment were in existence at the time of the first report on September 12, 2017. So the applicant first learned he had a disability by Dr. Silverman on September 12, 2017. And so according to Labor Code 5412, the date of injury was found to be September 12, 2017. So Code of Regulations says that a disability is considered permanent when the employee has reached maximum medical improvement, meaning that the condition is well stabilized. So it's unlikely to change substantially within the next year. So although in this case, they found that although permanent disability is normally reported when the applicant is permanent and stationary, it doesn't stop a physician from reporting a permanent disability existed before that time.
Okay, so here's where it's important for you, some pointers. When you have a dispute over when the date of injury is, you're going to be looking for things such as durable medical equipment, braces, a surgery. If somebody has a total knee replacement today, and even though they're not evaluated and given permanent disability until later, you know that permanent disability exists when they do knee replacement because that's a diagnosis-based estimate according to the AMA guides. This might differ if the doctor says that they're using an Almaraz Guzman analogy, no relation to that case. And if you have a verifiable cartilage loss, at the bare minimum, you may need a doctor to say that disability exists. And again, this could be PTD or PD. So why it matters to you is because if you have multiple defendants, or even if you have a CT, you can always look, okay, is there someone before me or after me, carrier, that I can pawn this off on because this person, maybe they had a CT that they filed, let's say last year, but now you have a new carrier and they're still working there, or even if they moved on to a new employer. But since they reported or filed their claim, their application, or even if it's just claim form, they haven't had any temporary disability, and you haven't modified their work in any way, but they're saying that all the heavy lifting that they're doing is what caused a CT for them. Well, I'll give you a war story. I have a case where I have a forklift driver that tried to run over another employee, and they were fired, and then they filed a CT, and they began working for a new employer doing the same job, exact same thing for the new employer, and filed an application against my client. What I did in that case, since I knew he didn't lose any time from his injury, I took his deposition. He said, he only lost like 2 days and he had a new job at another place and doing the exact same thing. Got him to admit that. Strategically, what I did there is, since he had lost no time and his job wasn't modified when he was with my client and it hadn't been modified with his new client, I postponed the QME evaluation till it had been more than a year after he had left employment with my client. Because although he alleges to know that he was injured for my employer, he still didn't have disability, and he still had injurious exposure because he's doing the same job. So by postponing that evaluation, in order to get to the date of injury under 5412, the doctor has to tell him that he has permanent disability. And in that case, I got the doctor to say that he had no time off because of his injury for my employer, and he had no time off for his injury with the new employer. He's doing the same thing. I got him to say that the same work would be injurious exposure. And then so he issued his report. It had already been more than a year. So in that case, I was able to say that the date of injury and under 5500.5, the liability fell on the new employer. So I still ended up settling the case, but instead of like 70,000, it was for 2,500 just to get out of the case because they had no liability with my client. The same thing happens if you have someone that has a cumulative trauma injury and moves onto your risk, onto your employer. If they already have an injury and they lost time for that other employer and they were giving a rateable report, but the case isn't finalized yet, and now they're working for you and they're joining you trying to say that, well, you're still doing the same job. A wise mentor of mine once gave me a good example of why that should stay with the other employer. If you jump in a swimming pool and get wet, whether you stay in the swimming pool for 5 minutes or 3 hours, you're not getting any wetter. So you've already been injured. So unless you have a break in employment or you change your job duties, that date of injury should not change. So that's how you shift that back to the prior carrier, because it goes by whichever occurs first, the last exposure or when you have disability. So if they've already been given disability and they missed time, they should stay with the prior carrier. Okay, now this next question is, if an employee is on their way to a medical appointment for your injury, is it a new injury or a compensable consequence of the prior injury? And again, this might depend.
So I'm a bit of a case law buff. I'm such a little nerd about it. But in this case, they looked at a prior case, Lanes, and in that they made the rule that an injury sustained as a result of medical treatment, which is occasioned by a prior industrial injury, is deemed compensable consequence of that injury. So it's not a separate or distinct injury, but arises out of the prior industrial injury. So just a little bit of history about what happened in Lanes. There was a motorcycle accident. The applicant was on his way to a medical appointment for the prior industrial injury, and he got in an accident. So the workers' compensation judge found that the applicant had sustained a compensable consequence of the applicant's earlier industrial injury. Well, the WCAB disagreed, so then the case went up to the Court of Appeals, and they had a different take on what the issue of the case actually was. If you want to go to the next slide, Martin. So the Court of Appeals in that case found that when an employee suffers an additional injury because of an accident, in the course of the journey to the doctor's office, the additional injuries are compensable. So basically what it says is, any sort of accident during a trip to the doctor's office, it's usually been considered sufficiently causally related to the employment just by the mere fact that a work-connected injury was the cause of the journey. So there isn't any, without any necessity to show that the first injury was in any way contributing to the fall or accident. So the employer is under a statutory duty to provide medical care, and in that same fashion, an employee is under a duty to obtain reasonable medical treatment. So they can't just be like, I don't want to go to treatment or anything like that. So by implication, the employer needing to provide treatment and the employer being going to get reasonable medical treatment kind of creates its own employment contract right there.
Okay, so in this case, the employee had an admitted stipulated injury in 2017 for the low back. And when they were on the way to a treatment, they were hurt. This is the ultimate conclusory fact. They were hurt on their way to a treatment. That is paid for by their employer. And because of that, they alleged a new injury, saying that on August 18, 2018, they were hurt when they're no longer working for that employer for 2 years or so, or a year, I'm sorry, and now they've hurt their back, ankle, and lower extremities. So I presume that in this case, they were attempting to maybe get some permanent disability onto that new injury that's attributable when they were traveling to their appointment. And so in this case, what happens is the employee is going to the doctor because they were injured, and that was approved in this case by the carrier. I don't know if most of you recall the good old days when we used to have applicant QMEs, defense QMEs, or an AME, and if the injured worker was hurt on the way to their defense QME evaluation, they would get that compensable. I had a few cases like that where they got into a car accident and were injured while the carrier was providing transportation to the defense evaluation, and that would land you with liability for whatever followed from there. And in addition, if the applicant attorney had set their evaluation, the applicant QME, that wouldn't be compensable because that wasn't at the request of the carrier. An AME would, but this case extrapolates on that because they're doing it. It extends the employment activity because the employer promised to provide insurance for them if they got hurt, and that was part of the bargain. And they're hurt, so they're going to their appointment. So it's part of that employment.
So what happened in this case, Martin?
Well, it went back to the judge to say, hey, take a look at this, and you need to reconsider that this was part of the original injury, and basically make your decision consistent with what we're telling you at this point.
Yeah, so there wasn't enough medical documentation in this case for there to be an actual determination. So they kicked it back to the lower, kicked it back to say, hey, we need some sort of treatment record, some sort of substantive evidence to address the actual nature and circumstance of the claimed injury, because they did not give any reason as to whether there was actually a compensable injury. So we have,
I was going to say that the underlying issue, if you're thinking or taking it to the extreme, this would not reopen the permanent disability because that's already been stipulated to. But it's a bit odd that they would allow this to go and be expanded after the stipulations. But it might not be any more different than if, let's say, you've been treating on non-steroidal anti-inflammatories and the doctor tells you that that caused a heart attack for you. That would be covered under your work comp injury as a compensable consequence because it's directly tied to the treatment and medication you're receiving. For me, this was a bit of a stretch.
So it looks like we only have 1 minute left. So Diane, are there any other questions for us to answer?
Oh, let me chime back in on the CT issue. I was going to cover this, but I didn't want to take up too much time, and we can finish up on this one. But for the CT claim, I also wanted to point out that it becomes important that when you get a CT claim, you take a thorough interview of the employee, because sometimes you'll get these skin and content claims where they tell you that everything was hurt. Your strategy on that would be to split up the causation between each body part. So for instance, if they allege hearing loss, and then they also allege low back, and they allege vision, those aren't going to be typically caused by the same mechanism of injury. So it would be good to do your interview and ask, when did you believe that your hearing or your heart or whatever was a work injury? What made you think that? Did you lose any time off of that? For each body part that you discuss with them, and you get them to describe the mechanism of injury so that it's different mechanisms. There was a recent case law where they tried to have 2 different body parts added, and that was rejected by the board, and they pointed out that a new application should have been filed for psych because it had nothing to do with the orthopedic injuries, because the doctor said it was due to stress or something like that. So that's what's important in that. And another point, A doctor cannot tell you what the CT date is. They can only tell you what activities were injurious and to a certain degree during what time frame they were exposed to those activities or that injurious exposure. Only a judge can give you a date, unless you, of course, you agree what the date is between parties. Okay, Diane, any other?
All right. So the question we have is regarding RFA. On a denied claim, some lien doctors send them month after month, and I have sent denials about a dozen times. Do I need to continue to send RFAs? Denials.
If the claim is denied, that is told and deferred, but you should have notes and a trigger and a diary to make sure you don't forget to submit the RFAs. If you need to submit them all at the same time, do it. But if you feel better that you can submit the RFA and get an answer now, you can do that. But the risk would be that you might miss doing it once you accept liability, if you accept liability.
Got it. Well, I would like to thank both of you for a thorough job today. I would like to add something in on Martin's comment about the different injuries at different times and trying to figure that out. Well, your medical records can do that for you, right? Because you're going to have doctor visits for each of those things. So when you need to get records, please be sure to call on MacroPro. And we have nurses that can do a synopsis on those for you. So if they're big dog ugly files, we would love to help you out and make it down to where you know exactly what the issues are and when they happen. We just did a case the other day where we had about 27,000 pages and they could not figure out why the injured worker was sick. And our nurses went through it and we found one line. She was living in black mold. It had nothing to do with work. And so we were able to really help the defense out here. And it was amazing because nobody caught that. So many people read those records. It was our nurses that did. So on that note, I'd like to thank you once again and remind everybody to check the MacroPro website for all of our upcoming webinars. We have webinars posted. They come up regularly. So be sure to sign in on that and we will see you the next time. Bye-bye, everybody.
Goodbye.
Hi, everyone.
That was my golf wave.